Good afternoon. Okay, so we are now on the local taxation and on fiscal matters. The local taxation is governed by Section 128 to Section 196 of the Local Government Code. Okay, so the first question is that in the national taxation, the power to tax is inherent in sovereignty. Then how about in the local government? Is it inherent in sovereignty? The answer is no. Because a local government is only a subordinate of the state, or it's only a branch of the government of the state. Now, before the 1987 Constitution, as I've already stated and lectured in Taxation 1, the power to tax of the LGU is a legislative grant. It is impliedly provided in the charter or the statute that creates a particular local government unit. But when the 1987 Constitution took effect, as found in Section 5, Article 10 of the 1987 Constitution, it is already stated there that the LGU has the power to create its own sources of revenue and to levy taxes, fees, and charges subject to such guidelines and limitation the Congress will provide consistent with the policy of local autonomy. It is a policy of decentralization. Okay. So that now, presently, the power to tax of the LGU is a constitutional grant. However, constitutional provisions are by itself not self-executory, so that it requires legislation. Okay. Now, the Local Government Code is merely a general law that delegates to LGU the power to impose taxes. It does not by itself impose local taxes. So it is the Local Government Code that makes the constitutional provision self-executory. But by itself, the provision in the Local Government Code on local taxes still needs an ordinance to be passed by the respective local sanggunian. Okay. In Section 129, it reiterates the mandate of the Constitution. Take note that it is not only on taxes that they have the power to levy and impose it, but also on revenues which are not taxes in nature, such as license fees, permit fees, or other charges. For example, if you go to some of the municipality in Bukidnon, passing by Bukidnon and going to Davao, there are comfort rooms there that you have to pay. Those are also what we call as other revenue raising power. Okay. Another important is that the LGU authorized to levy taxes and on revenues and other fees are only limited to 4: province, city, municipality, and barangay. Okay. Now, just like with the national taxation, under our general principles of taxation, there are what we call as constitutional limitations and inherent limitations. For local taxes, the fundamental principles found in section 130 would be the limitations. Was either be constitutional, inherent, and statutory limitation because it is provided by the local tax code. Now, Section 132 refers to the local taxing authority. Which is that? The sanggunian of the local government unit concerned through an appropriate, shall exercise it through an appropriate ordinance. Okay. Then Section 133 are the common limitations of the taxing powers of the local government units. If you will notice, Section 133, paragraph A, down to letter O, letter A down to letter O, are taxes which are already levied and imposed by the national government, of which the LGU are precluded to exercise their taxing powers on this object or subject of taxation found in Section 133. This is what we call as the preemption or exclusionary rule. What is that? It refers to an instance where the national government elect to tax a particular area, then it therefore impliedly withhold it to be taxed by the local government unless the national government will allow a particular object or subject of national taxation which can also be subjected to a local tax. Okay. So I draw your attention on Section 133A, Section 133I. So you study that. Okay. Now, Section 134 to 141 are the scope of the taxing powers of the province. Okay. Now, Section 142 to 100 142 to 150 refers to the scope of the municipal government. Section 151 is the scope of the cities, and Section 152 to Section 152 is the scope of the barangay. We study that. Okay. Now, if it is under the scope of the province, the municipality cannot tax the subject or object of taxation of the province. On the other hand, the city has the scope of the taxing power of both the province and the municipality. Now, another ticklish issue in the municipality's power to tax is Section 150. This is what we call as the allocation rule. Okay, so there are so many allocation here being mentioned, and one example is that which says that 30% of all sales recorded in the principal office shall be taxable by the city or municipality where the principal office is located. And 70% of all sales recorded in the principal office shall be taxable by the city or municipality where the factory, project office, plant, or plantation is located. And you take note also on the other allocation of respective share subject to tax. Okay. For example, in El Salvador City, you have the Asia Brewery, the manufactured beer. So, applying the allocation rule, the 30% of all sales of Asia Brewery in El Salvador will be taxed by the, I think it's in Makati City is their principal office, and 70% of that will be taxed in El Salvador City. So you study the allocation rule. Now, common revenue raising powers. Okay, so you read this and study what are those that are covered by the common revenue raising powers. Take note of section 155 on toll fees or charges. Okay. Now, section 156 refers to the community tax. Up to section 164. This is the community tax. This is the Cedula before and residence tax also called before. So, take note on who are those that are required to liable to community tax. It does not only mean individuals but including juridical persons. Okay. And take note also on section 159 exemptions from the community tax. Okay. Collection of taxes. Okay. Section 165. It says that tax period and manner of payment. Unless otherwise provided in this code, the tax period of all local taxes, fees, and charges shall be the calendar year. And it should be paid in quarterly installments. So, unlike with the National Internal Revenue Code, you have two kinds of year. You have the calendar year and you have the fiscal year. But in local taxes and other revenue, there is only 1 year, a calendar year. And you're allowed to pay your tax installments quarterly. Now, in section 166, this refers to accrual of the tax. So, when is the tax, local tax or other fees imposed by the local government become due and taxable? It becomes due and taxable every first day of January of each year. So it means therefore that for the year 2025, if you are a businessman, if you are a local taxpayer, your tax is already due on January 1, 2025. But you can opt to pay it quarterly as found in section 167. So section 170 refers to the rule of who is the one who can collect local revenues. It is the local treasurer. So all local taxes, fees, and charges shall be collected by the provincial, city, municipal, or barangay treasurer or their duly authorized deputies. Okay, take note that in the fundamental principles of local taxation, it says there that a local tax or fees cannot be let to be collected by a private person. Okay. So, when section 170 says that order duly authorized deputies, okay, deputies of whom? By the provincial treasurer, by the city treasurer, municipal treasurer, then who is that person? Okay. it's found in the second paragraph of Section 170 who can become a deputy. The provincial, city, or municipal treasurer may designate the barangay treasurer as his deputy to collect local taxes, fees, or charges. In other words, there is only one person who can be deputized by the provincial, by the municipality, or by the city. It is the barangay treasurer. Now, civil remedies for the collection of taxes by the government or revenues, collection of revenues by the government. So you have it there. Local government lien. Then you have the civil remedies, which is constituted by administrative remedy and by judicial action. Okay. Now, what is this local government liens? Okay. It refers to a charge of the government of which the government has a lien on your property if you become a taxpayer. It is automatic. It is by operation of law. So, all properties that we have, by the time that we become a taxpayer, by operation of law, it is considered that our property is already liable to pay our unpaid taxes. The same holds true when I discuss the National Internal Revenue Code, that it has also a national tax lien. Okay, so that if your property, for example, is sold to another person and you were not able to pay your local tax before you have sold it to another, that person who is the buyer, who is now in possession of your property, will be liable on your local taxes because a government has already a lien. Because a lien is a real right of the government. It will go wherever the properties goes, so to speak. Okay. Another thing also is that the priority between national lien versus tax lien, local tax lien, the national tax lien is has a priority over local tax lien. Now, how about if your property was mortgaged? Then, well, the property is still on mortgage by a bank. You become a tax delinquent, local tax delinquent. You were not able to pay your tax. Which is the priority now? The mortgage lien or the local tax lien? The local tax lien has priority over the mortgage lien. Okay, that is the nature of a local tax lien or local government lien. Now, on civil remedies, you have administrative action, the same with the National Internal Revenue Code, which I discussed on the national tax remedies. Levy, distrent, and forfeiture. The same principle that you will sell it to public auction. However, the difference is that in distrent, in the National Internal Revenue Code, there are two forms of distrent, as I have discussed before. You have the actual distrent and the constructive distrent. But in local taxation, there is no constructive distrent, only actual distrent. Then another remedy of the government is through judicial action, meaning filing of tax collection, local tax collection cases in court. But there is no criminal offenses in local taxation. Now, you also take note of Section 185, which is about personal property exempt from distrent. Okay. In the National Internal Revenue Code, there is no such provision. personal property exempt from restraint or levy. But in the local taxation, it is provided. Okay. Now, Section 186. What is this? Okay. It should be noted that as I have discussed earlier, there is an scope of the taxing powers of the province. There is an scope of the taxing powers of the municipality. There is an scope of the taxing powers and revenue powers of the city and also the barangay. Okay. So, does not mean therefore that only those that are mentioned as scope will become the object or subject of taxation by the LGU? The answer is no. Because if the object or subject of taxation is not excluded by them, to them rather, under Section 133, which I speak about the preemption or exclusionary rule, then the local government has the power to levy other taxes, fees, or charges under Section 186. Okay. This is what we call as the residual. Section 186 is the residual taxing power of the LGU. It's very clear. In Section 86, it says, local government units may exercise the power to levy taxes, fees, or charges on any base or subject not otherwise specifically enumerated herein or taxed under the provision of the National Internal Revenue Code as amended or other applicable laws. That the taxes, fees, or charges, however, should not be unjust, excessive, oppressive, confiscatory, or contrary to declared national policy. These are the limitations. More so, it also says that the ordinance levying such taxes, fees, or charges shall not be enacted without any prior public hearing conducted for that purpose. Okay. Now, how about the scope of the province, the city, municipality? For example, in the province, Section 100 134. Rather, 135. Section 135 is about tax on transfer of real property ownership. My question is that still need an ordinance so that it can be imposed? Section 135, kinahanglan bang ordinance? Okay. 135, kinahanglan bang ordinance? The answer is yes. But no need for publication. Why? Because that is not a new object or subject of taxation. It is already provided by the local government code itself. What I'm trying to drive at is that those object or subject or scope not mentioned in the scope of the province, scope of the city, scope of the municipality, or scope of the barangay, it needs an ordinance which has to undergo a public hearing. Because without any prior public hearing conducted for that purpose, that ordinance is not valid. Okay. Now, Section 187, it is part of my assignment, local tax remedies. What are your remedies? Now, Section 186, publication requirement. So, you read and study this. Okay. Now, you also read the case of Biden versus Mascareñas, GR number 135928, July 6, 2007. My question is that, supposing if there is a prior hearing, then the ordinance was passed, then it was not questioned to the Secretary of Justice. But the ordinance was not published. Is the ordinance valid or void? So, you study that. Okay. Then also, what is the meaning of publication? How is publication is being conducted? Study that. I do not want to spoon feed. Okay. Now, Section 192 is Section 190 is a form of a provision that impose administrative sanction to those who will attempt to enforce void or suspended tax ordinances and revenue measures. See, Section 191 is the authority to change the tax rates every 5 years, once every 5 years. Okay. Now, Section 192, authority to grant tax exemption. Okay. Now, under the implementing rules and guidelines of the local tax code, the local government units can give exemptions or reliefs, but only on under the following conditions: during natural calamities, civil disturbance, general failure of crops, or adverse economic conditions such as substantial decrease in the prices or agricultural products. It needs an ordinance. It would be applicable only prospectively and for a period of calendar year. Also, the LGU also has the power to give tax incentives on new investors in their respective local LGU. Okay. So, the taxpayers' remedies, these are my assignment to you. So, you should submit it for those who are under me in Xavier, you submit it tomorrow. But for the LCO, you submit it on Monday. Printed hard copy, including the remedies on the real property taxation. So, now, you also read the case of Valley Trading Company versus CFI of Isabela. 171 Iskra 501. The issue here is that, can the court issue an injunction to the local treasurer so that he will be directed by the court not to collect the tax? So, you read that case. You also study, aside from the tax remedies, you also study the prescriptive period for the assessment and collection of taxes. You also include that in my assignment. Okay, we'll have recitation for the Xavier tomorrow and for the Silisio next week. Thank you and good afternoon to everyone.